Miss Emily, okay, come to that first row, you're gonna go all the way to the end. No, behind the wall. Yes, all the way, that chair on the end. Right there. Mr. Moore, you're gonna go to the first row, you're gonna, one chair between you and Miss Ebeling, and you're gonna sit, you Mr. Two Mr. Moores, you're gonna sit next to Mr. Moore. Ms. Jones, you're gonna sit next to Mr. Moore, and Miss Miles, you're gonna sit next to Miss Jones. And Mr. Munoz Provost, you're gonna sit next to Miss Miles. Mr. Goolsby?
Yes.
You're gonna sit in that first chair, that second set of rows. Second set of chairs, right there, right there. Miss Sierra, you're gonna sit next, Sierra Figueroa, you're gonna sit next to Mr. Goolsby. Mr. Wolf, you're gonna sit next to Miss Sierra Figueroa. Mr. Miller, you're gonna sit next to Miss Wolf. No, you're gonna sit next to her. Sit next to her. Yeah, I know. That's number 11. Is that Miss Ward? Miss, okay, Miss Ward, you're gonna sit next to the, there's a chair between you and Mr. Miller. Sit right there, yes. Mr. Bernard, you're gonna sit next to Miss Ward. Mr. Pierce, you're gonna walk down that second row and go all the way down to the end. Go sit in that first chair down there. And Miss Landry, there's a seat between you and Mr. Pierce. Mr. Perkins, you're gonna sit next to Miss Landry. Miss Landry. Oh, wait a minute, hold on a minute. Wait up. 15, Mr. Pierce, raise your hand. And Miss Landry? Is there Miss Landry?
Is Ms. Vitanza, Your Honor?
Is Vitanza here? Okay, you sit next to Mr. Pierce. Mr. Landry is not here, so you're gonna have to, is there a chair between, okay. And that's Mr. Perkins? Lorendino? And Mr. Phillips. Good. Okay, everybody's here. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court today for a criminal case. Now, the criminal case that we have is a misdemeanor criminal case. This court, County Court at Law number 2, handle misdemeanor cases. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are normally referred to as petty offenses. Does not mean that they are not serious. It just means that they are not as serious as a felony case. Okay. Now, you will be examined for inclusion on a jury today. Our courtroom hours normally vary. Normally, we're in court in the morning from about 9 to 12. And then in the afternoon, we have our jury trials, usually start at 1:30 to 5. Whether you're not selected as a juror today, you are performing a significant service which only 3 people can perform. If you are selected, the case will be tried expeditiously, consistent with justice, which requires a careful and correct trial. If selected on the jury, unless instructed otherwise, you will be permitted to separate yourself at recess, for meals, and at night. Now, at this part of our voir dire, or our impaneling rather, I must administer to you the first of two administrative matters. Now, I need each and every one of you to raise your right hand, and once I finish administering this oath to you, please say, "I do." Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching your service and qualifications as jurors, so help you God? Okay, you may put your hands down. Now, ladies and gentlemen, the law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. I will first determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated on a jury, the case could be retried and you may be held in contempt of court and placed in the county jail for up to 180 days and fined up to $500. Now, the way I'm going to do this is I'm going to ask a series of questions. I do not want you to answer the question out loud. Just answer the question to yourself. And once I finish asking the last question, I will then ask, is anyone disqualified under the law? And if you think that you may be disqualified under the law, I will ask you to raise your right hand, and then I will ask each individual one at a time to come before the bench so that we can discuss the matter more privately. Now, when I use the term more privately, what I mean is this. First of all, this case is being aired on YouTube. We're going to turn off the YouTube. Next, my microphone will be turned off. Okay. And then I'll put on this noise sound device. And then we will discuss the matter outside of the presence of everyone else. Okay? Now, again, I'm going to ask a series of questions. When I ask the question, just answer it to yourself. And if you think that you may be disqualified under the law, at the end, just raise your hand and we'll have you to come up and discuss the matter more privately. Okay. First question. Except for failure to register. Okay. Except for failure to register, are you a qualified voter in this county, which is Jefferson County, and state, which is Texas, under the Constitution and laws of the state of Texas? Have you ever been convicted of a theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, the next question that I'm going to ask, I usually pause and explain to you that I'm asking this question because I'm required to ask it by law. I'm not trying to pry into your personal affairs. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a pettit juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? That was the last question. Now, is there anyone disqualified under the law? If you think that you may be disqualified, please raise your right hand. We have one person. That's juror number 19. Okay. And that's Miss Marindino. Okay. And so at this time, Ms. Marindino, would you come forward and court reporter? I have to Okay, is there anyone else think that they may be disqualified under the law? Okay. Now we will move to exemptions. And with the exemptions, I'm going to do the same thing, ask a series of questions. You may claim one of the following exemptions if you choose to, but you are not required to claim them. If one of these exemptions apply to you, but you still desire to be considered as a juror, Only thing you have to do is remain seated. You don't have to raise your hand. I will ask a series of questions, and then at the end, I will ask if there's anyone here who would like to claim one of the exemptions. First question. Are you a person over 75 years of age? Do you have legal custody of a child or children under the age of 12 years, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you a person who is an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county during the 3-year period preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces serving on active duty and deployed to a location away from your home station and out of Jefferson County? That's the last question. Now, is there anyone here who would like to claim an exemption? Okay, hold on a minute. It was juror number 1. And that was Miss Ebeling. Ebeling. And Miss Wolf. Okay. Anyone else? Okay. Miss Ebeling, you can come forward first. Let the record reflect that juror number 1, M. Janine Ebeling, has claimed an exemption. And juror number 2, Rima Charles Wolf, has also claimed an exemption. Now we will move to excuses. And the way I'm going to handle excuses, I'm not going to ask any questions. I'll make 3 statements. And if you think that you'd like to claim an excuse based on the statements that I make, you can raise your right hand. Now, a juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the defense and without the consent of the state. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an exemption? Claim an excuse. Let the record reflect that no one on the panel is claiming an excuse. We've had 2 jurors who claimed an exemption, and all the remaining jurors on the panel are qualified. Let the record show that the court is convened in cause number 23 CCCR 0020. The case is styled the state of Texas versus Paris Williams. The time now is 2:19 p.m. on today's date of September 17 of 2024. The defendant, counsel for the defendant, counsel for the state, and all members of the jury panel are present. Again, ladies and gentlemen of the panel, good afternoon. You have been summoned to this court as a prospective juror in this criminal case. The defendant, Ms. Paris Williams, is charged with the Class B misdemeanor offense of terroristic threat. The defendant is represented by attorney Wright Kimler. The state is represented in this case by attorney Andrew Hubel and attorney Haley Simmons. Our court reporter will be taking down everything that is being said, so speak up when you are answering or asking questions. The defendant is charged by information, again with the Class B misdemeanor offense of terroristic threat. And a Class B misdemeanor, the punishment range is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, or a fine from $0 to $2,000, or a person could be given both such fine and confinement. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs. but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we can discuss the matter more private. Is the state ready?
State's right, Your Honor.
Is the defense ready?
Yes, ready.
Okay. Is 30 minutes for each side enough?
That should be great, Your Honor.
Yes, Your Honor.
Okay. Mr. Hubel, the panel is yours.
Thank you, Your Honor. All right, good afternoon, everybody, and welcome to County Court Law number 2. First of all, I'm just gonna apologize in advance. I'm just coming back off of being sick, so if my voice sounds kind of nasally or strained, I do apologize, and I hope that you'll bear with me. With that, one thing that I do want to get across first, Judge introduced you to everybody, both, all the counsel and defendant. Does anyone recognize anybody, like, at the council table? No one knows anyone from the defense state? Great. So, you're here for jury selection. There's a fancy word for it called voir dire, and that means to speak the term. But and that's all we're really asking to do. We're not looking for any specific answers. We just want to know how you feel so that we can tell whether or not you would be an appropriate juror for this case. As Judge said, this is a Class B misdemeanor, a terrorist and threat case. This is the definition of terrorist threat from the Texas Penal Code. A person commits an offense if he threatens to commit any offense involving violence to any person or property with the intent to place any person in fear of imminent serious bodily injury. So with that being the definition, the elements of the state has to prove are that in Jefferson County, Texas, defendant on or about a certain date unlawfully threatens to commit an offense involving violence to the complainant with the intent to place the complainant in fear of imminent serious bodily injury. So, I want to ask you some questions about how y'all feel about the statutory language of the definition. First, concerning the threatening to commit an involving violence. And feel free to hold this answer until later and speak with counsel in the court privately. But have any of you been threatened by something? Juror number 3, Mr. Moore?
Yes.
Would you be willing to elaborate, or would you want to talk about it later? More privately.
Sure. As a business owner, I was threatened by an employee. At one point.
Was that a threat of physical violence?
Yes.
And how did you handle those?
In legislation.
So you didn't get involved in like the legal system. There were no charges.
No, there was not.
Given your experience with that situation, do you feel that you could be a fair and impartial juror?
Yes.
On this case? Okay. Does anyone have any similar experiences? Is that juror number 18, Mr. Perkins?
Yeah. I was a correctional officer for 40 years, so sometimes I would never write me the part of the job.
Yes, sir. And in those situations where they typically like outside of bars, environments, or both?
Well,
Um,
only in the prison, not outside.
right. And then, so you said that no charges were filed in any of those situations?
No, I just wrote testimony reports. With that.
I'm sorry, could you say that again?
I just wrote a disciplinary report because I was supposed to do
And given your experience, with those situations, do you think that you can be fair and impartial in this case?
Oh, yeah, I don't take it personally. I would go.
So that was part of the job for you,
Right.
but you can see how someone not within your, career path, when faced with something like that, might have a very different reaction.
Yeah.
So. That would bring me to my next question. Does anyone have any idea, just what does the threat look like to you? Any volunteers? So it's a, to you, the threat would be a threat of physical violence? Okay. And how do you determine if something said by someone is a threat? Okay. So you would just like the statement that they made? So they, just based off the statement they made, like, say someone said that they're gonna punch you, that's the threat of them punching you? Okay, okay, so like, a simple assault wouldn't be enough for, okay. Is there any other way that, one might direct, one might make a threat to another?
I would read body posture.
Okay,
You could feel.
okay. Mr. Moore, Brandon Moore, juror number 4. What if, say that you were speaking to someone that you knew, and through your contacts with them, through your relationship with them, you know that something that they just said to you, through what they just said to you, they're trying to tell you that they're going to do something violent to you. Like, they don't say that they're going to punch you or that they're going to shoot you or stab you, but you know, based on your relationship with them, based on the context between you, that something has been, that message has been sent. Do you feel like that would be okay?
Yes, sir.
Um, Ms. Jones, juror number 5. Would you, is there anything else you would consider in, like, not just whether something is a threat, or how would you gauge the level of threat as well?
If it's not something that's verbally said, it would just be a
Is, would you consider potentially the ability for the individual to carry it out? Is something that's important? Now, is there anyone else who would consider the ability to carry out the threat as an important, consideration? By show of hands? Okay. That's jurors number 11, 15, and is that 19? Now, the threat itself, we've talked about, but in regards to the offense involving violence, gonna see if we can name a few examples, Ms. Miles. Can you give me an example of an offense that involves violence?
I guess when somebody trying to shoot you with a gun, maybe?
Okay, so, aggravated assault with deadly conduct. Mr. Krivos, can you think of an example?
Speak up, please.
Physical altercations.
Okay. And of course, you have stuff like robbery, murder, you know. See, this is, aggravated assault is one of the answers, it's one of the examples that we talked about. So you can see like in the language, that it says, like, commit assault, serious bodily injury, it's those kinds of things that are like inherently wrong. Um, let's see if I can, get a volunteer for this one. Is fear rational? Is it always rational? Okay, so it's always something that has to have a rational basis, or, and by that I mean it's always something that, like, that you're always scared of things that you were realistically in danger of.
I can't hear.
I'm sorry, I feel like that'd be a personal thing, like people are fearful of different things. That would be a personal issue.
So the juror number 11, Mr. Miller. So are you landing on the side that fear is always rational, or that there are certain times where, fear arises even in irrational situations?
I would say. Yeah, I would say it personally would always be rational.
Okay. But have you encountered people in your life that have experienced fear in irrational ways, or at least in your view? Does anyone else think that or does anyone think that fear is not always a rational response? That fear can sometimes take place, like, that it's a feeling, essentially? Do you have any thoughts on that, juror number 16, Ms. Matanza?
I think fear is a feeling, yes,
Okay.
it's a personal feeling.
And it doesn't always necessarily have to have like a rational basis for existing.
No, after snakes, and I think that's probably pretty rational.
So on to that next question, what is, let me ask juror number 8, Mr. Goolsby. What is eminent to you? What does the word eminent mean to you?
My dear, right in front of you.
Okay. So how far does right in front of you extend? Like, let's say, for example, and this is only for example, of course, because we're in a court of law. I make a threat of violence to you, from where I'm standing. Would that be eminent enough to you?
Not very close.
Okay, so if I said, for example, I was gonna stab you with this gun. From that far enough, that would be eminent enough for you? You would still say it's too far, or is that eminent enough?
No, that's it.
Okay. And it looks like juror number 14, Mr. Bernard, you had a thought? Oh, okay, I'm sorry. I may have seen you messing with your glasses and thought they were so hard. Sorry about that. Is that Miss Sierra Figueroa? And would you agree with Mr. Goolsby's definition of eminent, or, do you have any different ideas about that?
I agree.
Okay. Does anyone differ, from what they're, saying? Okay. So basically, like, eminence seems like, based on what I've talked to you, and you can, agree or disagree with me, juror number 8, that it's context dependent. Okay. No, what about intent? Come back to you, juror number 11. How do you determine, the intent of someone whenever they make a statement.
Guess maybe their level of anger or emotion in the situation.
Okay, so, like the statement itself in the context in which they say it.
Perhaps.
Does, in your question about touching on this whenever you answer, the emotional state of the parties matter? Okay. Now, do you remember 13 this word? Now, how would you, like in a situation, evaluate the emotional states of each party? Like, which one would you consider first? The emotional state of the person making the threat or the person receiving the threat? What's most important to you?
The one making the threat.
Okay. So their intent, would matter more to you, evaluating the situation. Okay. And, if someone makes a threat of violence, involving a weapon to you, whether that be a gun or a knife, do you necessarily have to see that threat for it to be imminent? Do you necessarily have to see that weapon for it to be imminent to you?
I don't think I'd have to see it. If they said they had one, then I would believe them. I mean, you
I
know.
mean, because nowadays, like anyone could be carrying, um, in our state, but likely not in here because of our wonderful bailiffs. But there is a threat, if someone makes a threat of gun violence to you, that they might be concealed carrying, or that if they threaten to stab you, they might have a knife in the person. You can't necessarily always see that. So, just looking back at the elements, real quick, Mr. Bernard, juror number 14, what kind of evidence do you expect to see in a case like this?
The threat.
Okay, so you would expect to see like some sort of video evidence of the threat?
Witnesses, not necessarily video, but witnesses,
Testimony?
yes.
Okay. And who would you like to hear from in that case?
Received.
Would you also maybe want to hear from some other individuals?
Bystanders.
Okay. What about responding officers?
Sure.
Okay. Now, we just talked about this, but does everyone recognize that testimony is evidence? Like a lot, anyone not familiar with that concept? Because I've had people before who think that evidence is only the physical exhibits that are offered and admitted, but testimony is also evidence for y'all to consider. Everyone understand that? Okay. And as far as considering evidence, and as well as testimony, I go saying, consider all the testimony that's given in court and only the evidence that's offered and admitted, like in regards to evidence. Okay, so I'm gonna ask you a couple of scale questions really quick. If you could just look at the question above, are threats of violence something to be taken seriously? Either 1, strongly agree, through 6, strongly disagree. If you could all get a number in your head, I'm just gonna go by real quick. Juror number 3,
2.
juror number 4,
2.
juror number 5. Juror number 6,
Three.
juror number 7, juror number 8. Was that a 3, sir?
Number 2.
Oh, 2, I'm sorry. Miss Sierra Figueroa, number 9. This is 2. Juror number 11,
3.
Juror number 13,
2,
juror number 14,
3.
juror number 15. Juror number 16,
2,
juror number 18, 3. Juror number 19.
Aye.
And juror number 20.
2.
And so all of this, I mean, all of y'all landed in the agree camp, whether it's agree or somewhat agree. So Mr. Pierce, juror number 15. Why are threats of violence something that we need to take seriously?
You never know how far somebody's gonna go.
Right. And you see on the news every day how like red flags, threats of violence that are left unaddressed turn into acts of great violence later. So threats of violence, even if they seem small at the outset, we can all agree that there's something to be taken seriously. And with that in mind, one more scale question. With the offensive Terrence threat, and based on what we just discussed, how important it is to y'all that the state prosecute these kinds of cases. Juror number 3.
Two.
Juror number 4.
2.
Juror number 5. Juror number 6.
3,
Juror number 7.
3.
Juror number 8.
2.
Juror number 9.
2,
Juror number 11.
2.
Number 13.
2,
Number 14.
3.
Number 15.
2.
Number 16.
2,
Number 18.
2.
Number 19. And number 20.
2.
So now that we talked a bit about the substantive law of the case, I'm just gonna move on to some general principles like regarding the state's burden. And the state is the only party in this case that has a burden. Why is that? Juror number 16, can you tell me why the onus is on the state in proving these cases?
Is it a threat? Maybe to the state, I don't know.
Oh, well, I can answer that question for you, It's because the defendant has something called the presumption of innocence. Which means that they are presumed innocent in unless the state can prove the elements of the offense beyond a reasonable doubt, and that's my job.
Sorry, I misunderstood the question.
Hmm?
I misunderstood the question.
Oh, no, that's okay. So the defense doesn't have any burden, they don't have to show anything, and they don't even have to speak. The defendant has, in fact, has the right not to testify, and you can't hold that against them. Can we all agree to, if the defendant decides not to testify, that you will not hold that against them? So, as a state, we have the burden to prove, the elements of the offense beyond a reasonable doubt. And if the state succeeds to do so, you must vote guilty. And if the state fails to do so, you must vote not guilty. Then it's always important to consider that, the only doubts that you're supposed to, take into account are reasonable ones. Now, what does that mean? Beyond a reasonable doubt? We can't supply you the definition. But it does not mean that it's beyond all doubt, or beyond the shadow of a doubt, or the stuff that you would usually see in like a legal drama. It's something that I would ask you to use the ability that you use every day in making decisions, your common sense. And just as an example, juror number 18, what do you see on the slide?
Puzzle pieces.
Okay, and for just those 3 pieces alone, can you tell what the whole puzzle depicts?
No, I could just barely see it, just see the black piece, I don't see the other pieces.
Okay. But How about this?
Yeah.
Okay, so even though there's some, pieces missing, you can tell what, the puzzle fix,
Correct.
and what is it?
It's good.
Okay. And you would say that even though there's some, like some missing space there, that beyond a reasonable doubt, in your view, beyond a reasonable doubt, that puzzle depicts it on.
It could be a toy gun, but it's in shape of a toy.
Okay. So, see, like, so the puzzle is like this case. Evidence, the evidence that will be introduced, whether it be, exhibits or through testimony, or are like pieces of the puzzle. And, it's the state's job to make sure that the evidence that is introduced, the puzzle pieces that you get you to the point where you can say beyond a reasonable doubt that the defendant committed this offense. And the important, part of testimony is the witnesses. And like the most important trait of a witness is their credibility, because if you don't know whether or not you can trust what they say, then what they're actually saying is meaningless.
We have 5 more minutes.
Um, Ms. Mirandino, how would you evaluate a witness's credibility?
Like, put me in a high, body language is around.
Okay, and are these things that you look for and that you use in everyday life to evaluate the credibility of people you're talking to?
It's ain't a problem.
Okay. So, and I agree with you. I think that's the best, I think that's the best way to handle evaluating someone's credibility, using, the skills that you do every day to, to evaluate whether or not someone's telling you the truth. All witnesses should start off with the same credibility regardless of regardless of who they are. Can we all agree, whether in a witness is either just an individual in the community or a law enforcement witness, that we treat their testimony with, equal credibility at the start? Okay. Now, from the start, you can go one way or another with it, but at the start, everyone starts equally. Can everyone agree with that? Okay. So, one important thing that I want to get to is the one witness question, this one witness question. So, let's see, jury number 20. Suppose a single witness who you believe beyond a reasonable doubt, you believe this person beyond a reasonable doubt, lays out all the required elements of the case. Would you be able to vote guilty solely based on that one person's testimony? And
I would still have to consider that they could be innocently wrong in their presumption. So to judge it properly, I would have to wade through that.
okay.
They may be sincere, but they could be wrong.
And I guess that'd just be something that you would have to evaluate their credibility on.
Every time, yes.
Okay. And suppose for this hypothetical, you made that consideration, you weighed their credibility, and you believe them, you believe that they are honest and correct. Would you be confident in making that vote then?
Correct.
Okay.
Yes.
Does anyone disagree with that? Would anyone have a problem if there's only one witness?
I feel like there would be more elements to the case than just a single witness open and shut, right? Is that what you're asking?
Well, that would depend on the case. But that you would have difficulty if there was just one witness.
I mean, if one witness statement was everything the case read on, I guess I would have to evaluate it at that time, but. Sure.
And that's okay, like, there's no such thing as wrong, as a wrong answer in this, like we had said at the start, we're just trying to gauge y'all's opinion on these things. Anyone else have potentially have an issue if there's just one witness? Okay. Once again, these are the elements the state must prove in this case. In Jefferson County, defendant on or about a certain date unlawfully threatened to commit an offense involving violence to the complainant, but with intent to place the complainant in fear of imminent serious bodily injury. But y'all's job here boils down to these three things. You would evaluate the facts, like the evidence that's produced in this case, for y'all to consider. You would hear all the evidence and determine what the relevant facts of the case are. Then you would be supplied with the law in the court's charge, and apply that law to the facts of this case and render a true verdict of either guilty or not guilty in this case. You want a true verdict and a unanimous verdict. Can you all do that? Okay. Is there anyone here who feels that they cannot sit in judgment of another for religious reasons or any other reason? Okay. Any questions, anything that y'all feel I didn't cover that I should have covered during this presentation? All right, thank you all very much. I appreciate all y'all's time and I look forward to presenting this case.
Mr. Kipling, panel is yours.
Anyone need a break right now? We're gonna move on. Want a break? I'm ready to get on with. Anyone here object to this being broadcast on YouTube? I have a problem with that. I don't personally, but I've noticed, you know, some people might. People have on the internet. All right. How many of you served on criminal juries before or been through this process before in another court? Ms. Ward, Mr. Townsend, Mr. Moore, was that right? And Mr. Phillips, right? Mr. Phillips, what do you think? What are we doing here with Ward Hour? What's the purpose of this process?
Judge our prospects as a competent jury.
Okay, do you think that we're selecting people off of the panel to serve, like I get to pick some, Mr. Hugh? Okay, Mr. Moore, you agree with that? Okay. Mr. Bernard, do you agree with that? I agree. Mr. Townsend?
Yeah.
Okay, would it surprise you to know that each of us get to eliminate 3 people and the first 6 that are left are the jury? So we're really trying to identify whatever reason people that we don't think are favorable to our particular sides, and in theory is the first 6 that you're left with are at least acceptable to both sides, so they can be neutral. Yeah, for instance, you get this a lot with DWI and driving intoxicated cases where somebody on the panel, multiple people sometimes have had family members or loved ones that they killed or injured by intoxicated drivers. So they really aren't dispositionally suited to be fair and objective in a driving while intoxicated case. That means they would be good jurors in a terroristic threat case or a trespassing case or some other kind of case, but just the particular facts of that particular kind of case, a person is unsuited because of their past experiences impacting their objectivity to sit on that jury. So this isn't the type of case I really anticipate that problem with an alleged terroristic threat. But do any of you feel, I mean, I think Mr. Hugh might have covered this, that either you or a loved one may have been threatened in some way or some capacity where your objectivity in evaluating the state's proof in that type of case would be called into question? No one? Okay. How many of you here, when you walked in, you saw Ms. Williams sitting there at the table with the actor, said, well, gee, I wonder what she did wrong. Ms. Ward, do you think that or not? Wonder what she did wrong?
I kind of do.
Kind of, why isn't it?
Well, she's sitting right there. I mean.
What does that mean, somebody sitting right there?
She's being accused of it. I don't know.
What does that mean, she's done something wrong?
Well, no, I guess not.
Yeah, to ask that question, what's that? And I got a guy on the front row responding, I didn't think she did anything wrong, I thought you were the defendant. He didn't. So you got scratched on. But anyway, what about anybody else? You think she done something wrong with her, Jules, what do you think? Think she's done something wrong?
Oh, yeah.
Don't know, right? Why is that?
So that for the evidence and for what is.
Right. What are the magic words we always hear? Presumed innocent, right? Presumed, what does that mean? She's presumed innocent. Presumed to have done nothing wrong, no shake, no how, no way, right? Do juries make that determination once we have a trial and you hear evidence? Do juries find people innocent? Mr. Goolsby, do you think?
So
Who agrees with Mr. Goolsby? Juries find people innocent, showing anything. Okay, Ms. Marandina, why did you think juries find people innocent?
the juries are for, they were trying to take on.
Now, I told you, done nothing wrong, Pierce have driven snow, innocent, that's what innocent means. Can juries make that determination? That kind of certainty? What was OJ found not guilty? Or was he found innocent? OJ Simpson, what was he? Was he innocent? Was he, didn't go down off Pierce, driven snow, didn't do anything wrong, was OJ innocent? Man, but the jury found him, what did the jury find? What did they find? Mr. Townsend, what did they find? Not guilty, right? Does not guilty mean innocent? Mr. Goolsby does not guilty mean innocent. What does not guilty mean?
They didn't do whatever the.
No. You're close. Doesn't mean they didn't do it. What does not guilty mean, anybody?
Wasn't proven.
They didn't prove it, right? They didn't prove it beyond a reasonable doubt. That's not the same thing as innocent. Get tired of hearing, watching TV shows, or they're in my client's innocent. No, my client's not guilty. They can't prove it. I don't have to prove that she's innocent. I gotta prove they had enough to burden to prove. Right? That's it. Everybody agree? What's their burden of proof? Those of you who've been on jury panel before, that's or anybody. What's the state's burden of proof? It is a crime. Congratulations. Proof beyond a reasonable doubt. What does that mean?
There's no doubt.
No doubt.
They proved it.
What's your answer? How many people agree with Ms. Thompson? No doubt. Show of hands. How many people agree with no? Well, I'd like that to be the law of this. It's proof beyond a reasonable doubt isn't absolute certainty. It's not just like on the innocent side where a jury doesn't say somebody didn't do it, they're innocent, pure as driven. So on the other side, guilty doesn't mean absolute 100% certainty. It's proof beyond a reasonable doubt. And that's such an important concept or idea. Do you think Judge Holmes is going to give you a definition for that in the jury instruction? Tell you what it is, what proof beyond a reasonable doubt means? Right? Sure. No, it's not defined. Court of Criminal Appeals has said it's up to each one of you that are selected as jurors, come up with your own mind what proof beyond a reasonable doubt means. How high of a standard that is, how difficult of a standard is that to meet for the state of Texas to meet before a person can be convicted. How difficult of a burden is that going to be? It's not proof beyond all possible doubt. It's proof beyond a reasonable doubt. What happens, Mr. Pierce? What happens if a person is convicted of a criminal offense? What's the next step?
They get charged.
Well, they're already been charged. She's charged right now. What's happened after a conviction? If somebody's convicted,
Sentence, right?
sentence. What does a sentence mean?
What? I guess they're punishment.
Punished. That's the magic word. They're punished. What kind of punishment can a person get in a criminal offense?
Jail or fine.
Prison, jail. Prison and jail are different. Jail's in the county, prison, you go off to a state facility. Jail is for misdemeanors. What else? Fine,
Fine.
executed, right? State of Texas, you can be executed if you're convicted of violence. We're not dealing with that serious of a punishment here, but it's a class B misdemeanor. It means you could go to jail for up to 6 months. But one step above a traffic ticket. So there's a possibility of deprivation of your freedom. You're locked up in the jail, eating the trays of food. You don't get to, call out for pizza. And you're living in the dorm with a bunch of other people. unreflectable hiding, but you're stuck losing your freedom for up to 6 months. And how important is your freedom to you?
Very important.
Right, what's more important than your freedom?
Nothing?
Children, you got children?
Oh, yeah.
Yeah. All right. So children, but maybe next to children, right, freedom's up there. So when you're sitting back, those of you that are selected to start in this case, you're trying to figure out how high of a burden of proof beyond a reasonable doubt actually is. Just think about the consequences of making a positive finding of that somebody can be deprived of their freedom. And how certain do you, how much surety do you want before you're willing to deprive somebody of their freedom for 6 months? In a class B misdemeanor. That kind of puts a frame on it. So that's the way I see it, but you're free to come up with any working concept, that anything that helps you to come up with an idea of what proof beyond reasonable doubt is, because those Holmes isn't going to find it. All right, this is a terroristic threat. States talk to you a little bit about fear, which is kind of an interesting concept in itself. You'll notice that the way the statute is written, it's not actually required that the person who is victim in the case is in fear. It's placed in fear. Somebody could make a terroristic threat to someone, and the person that is the recipient of the threat is not in any way fear at all. And the offense is still committed. It's just what the intent of the person speaking the threat is. They intend to place somebody. The actual fear, whether a person is placed in fear, isn't an element, isn't an issue in the case. It's what the intent of the person making the utterance is. Do they intend to place somebody in fear? Or they just say, I was just kidding, I didn't mean that, I didn't mean to put anybody in fear, I was joking, that kind of thing. I was interested, Ms. Matanza, why are you afraid of snakes?
I always have been.
Why? Why?
I said it's irrational.
It's irrational.
Yeah, I don't know.
So if somebody that knew you threatened to throw a snake on you, they would know that that would place you in fear. I represent to you just, this isn't really relevant to the board either. Not all snakes are bad. I mean,
I understand.
last week I had a chicken snake that I rescued from the dogs in the backyard. Threw him over the fence to save him so he could go kill some rats. Now, if it had been a copperhead or a barb, it might be a dangerous snake instead of. But I understand because I'm afraid of flying, which is irrational. Are you afraid of flying?
Yeah.
See, there's what we do there. And I don't care how many times people tell me more people die in car wrecks than planes. Every time you get on the plane, you think about the ones that crash, and that's exactly what all the people that are on the plane that crashed thought when they got on the plane, that driving safer than flying. But anyway, it's the fear, the intent of the person that's allegedly uttered the threat. That's what matters with fear. And how do you know what somebody's thinking? How do you know what their intent is? We have to infer it from the surrounding circumstances, right? You can't get in their mind and look. What about, I'm gonna hurry up too. I know you're probably tired of sitting there. There's a couple other things I want to cover. Credibility of witnesses. Judge Holmes, I anticipate, is going to give you instruction in his charge to you, a written charge document containing the law of the case. He's going to tell you that jurors are the sole judges of the credibility of witnesses. You can believe all, part, or none of whatever any particular witness tells you. Now, Ms. Marandino, you indicated when Mr. Hubel asked you, how would you judge a witness's credibility? What did you say? That the eye contact, body language, demeanor, right? Anybody else have any ideas on judging the credibility of witnesses? Because the first thing you got to determine is whether a threat was actually made, right? So what, Mr. Phillips, what do you think as far as judging the credibility?
You have to judge if they have the capability of actually carrying that out.
Well, how do you get, before you get to that, how do you judge if they're telling you the truth that the threat was even made, that the utterance that occurred? How do you get to that point?
Situational awareness and
No, maybe they're lying, maybe nothing was said at all, and they're lying about it. How do you judge the credibility?
I need to see proof of it.
What kind of proof besides the person saying that it happened when they're under oath? Let me ask you this, you think people, they get up here on this witness stand right here, and they raise their hand and swear to tell the truth? Do you think people still lie?
I think 10 should go free before one innocent doesn't.
But do you think people say, I'm not making an allegation of any particular person, I'm just saying in general, do you think people do that and still lie? Sure. The oath,
Or they're wrong.
or they're wrong. or they could be mistaken, right?
Correct.
And that's true in a lot of cases. It's not whether they're lying, but whether they're accurately
Perception.
perception. And that is another question. You're absolutely right. But what about lying, credibility? What do you look for if somebody's telling you the truth? If you want to evaluate if somebody's telling the truth, what would you do? Say you're a police officer, somebody gives you a story. How do you go about verifying what they're telling you, whether that's the truth or not?
Looking at them very intently,
Right? Use,
make them know their body, body language. If you will.
okay, body language.
And if I have a history about them, then I already know a little something.
Okay. Any of you watch true crime on YouTube or anywhere else, a true crime show? And I'm just the only one, there are a lot of people that kill their spouses, I'm just saying, right? And some very creative ways, poisoning, getting somebody else, trying to hire somebody else to do it and just setting it up like they committed suicide, I mean, so. As a lawyer looking at this, if your spouse ever dies under questionable circumstances, you better have an idea why you didn't do it, right? And it's not gonna be, you watch the interviews, it's not enough that the person is crying, that the surviving spouse is crying and saying, I didn't do it, this is so terrible. What do the police do to evaluate that person, whether the surviving spouse is telling the truth?
Gather the evidence.
Yeah, the evidence, they look to see if there's corroboration. I was working all day, I could have been home to kill my wife. Here, all these people at work saw me, here's my time cards, here's the video. Saw one guy, it was the other day, with his spouse, it was his mother, actually, and they had a video, this was up in Iowa. And he had driven an 18-wheeler full of grain to Cargill, to a grain processing plant. There was a video of him at the Cargill grain processing facility an hour before his mother, the time of death, and it would have taken him 2 hours to have driven there. So that really saved him. Even though they had a jury trial, he was found not guilty. So you look at corroboration. What's the corroboration? Is there any corroboration of what the person is telling you? Right? Sure, body language, demeanor, all that. What's the corroboration? That's why we have body cams. Or with police officers and a lot of times. And that's to protect the officers as much as it is to gather evidence. You can think of a situation, if you're a law enforcement officer and they have a relative that's in law enforcement and they're out by themselves patrolling and they have to arrest some, ladies don't hold this against them, but they have to arrest some drunk, an intoxicated female driver. Well, there could be all kinds of allegations that are made against that officer in that context that if taken at face value, they just make the allegations and you believe it could cost them this career, possibly prosecution. Well, that's why that body cam is there, to protect you. To go back and see if there's any corroboration. So that's one thing you can look at, is there any corroboration when we talk about in this context, whether these statements were actually made or whether you have a reasonable doubt. See, whether you have a reasonable doubt whether they're in. So, all right, that's about it. Y'all have any questions of me? No? Okay, we'll give some time there.
Okay, ladies and gentlemen, both the state and the defense has concluded questioning you at this point. We're gonna ask that you follow the bailiff into the hallway. Now, we may ask some of you to come back in the court for some follow-up questions. So at this time, the court will be in recess. You can go out either door, either the right or the left door. Okay, at this time, you can stand and exit the courtroom. At this time, the court will be in recess. The roll, please, sir. Y'all can be seated. Let the record reflect that the court is back in session. Court is in session and calls number 23 CCCR 0002. The case is styled the state of Texas versus Paris Williams. Let the record reflect that Ms. Williams is present in court with her attorney, Attorney Wright Kimmer. Let the record reflect that state is present with Assistant District Attorneys, Attorney Andrew Hubel and Attorney Haley Simmons. Let the record also reflect that the jury panel is now present and seated in the courtroom. State, are you ready?
State's ready, Your Honor.
Defense, are you ready?
Ready.
Okay. Ladies and gentlemen of the panel, when your name is called, please walk to the jury box. There's a tag that's on the top of the jury box, and just pick up a tag, and you can pin the tag while you're sitting down in one of the seats. Okay, again, Ms. Trina Redmond is going to call your name, so when your name is called, please walk to the jury box and the bailiff will give you a tag. Okay, Ms. Redmond?
Charles Moore,
Charles Moore,
Brandon Moore, Rosemary Jones, Tiffany Miles, Carla Sierra Figueroa, Ricky Bernard, Shelley Batanza,
okay. Okay, ladies and gentlemen of the jury, as I mentioned to you earlier, I had 2 oaths to administer. I administered to you the first oath during the impanelment. Now I need to administer the second of the 2 oaths. Will each and every one of you raise your right hand, and once I finish administering the oath, please say I do. Do each of you solemnly swear that in the case of the state of Texas versus Paris Williams, the defendant, you will a true verdict render according to the law and the evidence, so help you God? Okay, you may put your hand down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions interpreting them and how they may apply to this case. You and I have equal authority, but there's divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses, or objections to the introduction of documents or objects. This means, in the objecting attorney's opinion, there is a legal reason why you should not receive the evidence. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can't hear the discussion on the point of law. The reason for that, as I mentioned to you earlier, you are the sole judges of the facts you receive, and I'm the judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of law. The reason why I will sometimes ask you to step outside is because it's simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her, and the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you should disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of this case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspaper or watch TV reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. Now, the badges that you're wearing, please wear those badges at all times because those badges identify you as a juror in this case. Ladies and gentlemen of the panel, those of you who were not selected, first of all, I would like to thank you for taking out your time to be here this afternoon. Our criminal justice system, or our justice system, cannot function without people like you who take time out from your busy schedules to come to court to make sure that justice is done. I know that when you came to court this afternoon, you probably looked over the top of the door and you saw the words County Court at Law number 2, Judge Terrence L. Holmes, and you probably said to yourself, oh, this is Judge Holmes' court, I'm in the right place. But this is not my court, this is your court. I'm only an humble servant of the citizens of Jefferson County. And I said that to say this. Anytime that you're in the area of this courtroom, County Court at Law number 2, please come and have a seat and see what goes on in County Court at Law number 2. You can sit in the area that you're sitting in, we call that the peanut gallery. But it does not mean you can bring peanuts in here and eat, because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom to see what goes on in Jefferson County. Now, if you cannot make it to the courtroom, you could just simply tune in on YouTube. And you can see what goes on in County Court at Law number 2 in Jefferson County, Texas. Now, your jury service is complete. The bailiff, she has a letter for you. Please feel free to read the letter. If you'd like to drop a line to County Court at Law number 2, please feel free to drop a line. We like to know how we're doing and what we can do to improve the justice system here in County Court at Law number 2. Now, normally, I usually will give each individual a handshake. You know, we still have COVID in our community. However, I will give each and every one of you what I would call an air handshake. Okay. Okay. Now your jury service is concluded. The bailiff have letters from you. We ask that you please stand, and each and every one of you have a blessed day. Okay. Okay, you may be seated. Now, state, when are we going to present our evidence?
Tomorrow afternoon, Your Honor.
Okay, tomorrow afternoon at 1:30?
Yes, Your Honor.
Okay, so ladies and gentlemen of the jury, the state will be presenting the evidence in this case starting on tomorrow afternoon at 1:30. And just a little preview of what's going to happen. The state is going to read the information. The information is the charging instrument. If it was in felony court, it would be called an indictment. But in misdemeanor court, they call it an information. So the state is going to read the information, and the defendant will enter her plea to the information. And then the state will have a right to have an opening statement. Defense has a right to have an opening statement. After opening statements, then the state will start its case with their first witness. So that's what will happen on tomorrow. Now, tomorrow we're going to start back at 1:30. We would ask that everyone will be here on time at 1:30. So at this time, you are excused for the afternoon. And everyone, please stand. Now, you can take the badges home with you as well. Now, everyone, please stand as the jury exit the courtroom. Now, you can follow the bailiff. Okay, you may be seated. Say, do you have anything further? Defense?
No, sir.
Okay. The court will be in recess until 1:30 on tomorrow.
Thank you, Judge.
Okay, you're welcome.